we'll go ahead and get started. Before we go into the actual calling the meeting to order, up until we go ahead and elect the chairperson and vice chairperson, I'll go ahead and bring us to the meeting. So without further ado, I'd like to thank everyone for joining us today to this Public Defender Service Corporation Board of Trustees meeting of our first newly constituted board. I'd like to thank everyone for being on our board. And we'll go ahead and call this meeting to order at 12:40 p.m. Tuesday, September 23rd, 2025. Okay, first we'll go through roll call. Our first for this board. We'd like to start with a board member. And I'm sorry, would you like us to refer to you as doctor? Okay. Board member Artemio Ricky Hernandez, PhD. Board member Dr. Christiana Whitman. I believe she is in trial at the moment. Board member Mrs. Donna Muñoz-Canata, welcome.
I'm present. Thank you. Today.
Board member Attorney Shane Black, present. Board member Attorney Jeffrey Moots, present. Board member Attorney Joseph Perez,
Present via Zoom.
thank you. And board member Attorney Janet.
Hi, present. I'm not sure why my camera's not working. If you can help me out, if it's on your end or mine. But it's not that important, I guess.
We sent
There
a
we go.
request.
Okay.
Right, thank you. So as per the roll call, we have a quorum established for our meeting today. And just to go through a little bit of the housekeeping, notice of the meeting was duly published in accordance with all statutory requirements on Tuesday, September 16th, 2025, and Friday, September 19th, 2025. To get us going at this point, before proceeding to the next agenda items, I'd like to put a recommendation out to the board that we move to proceed with elections of the chairperson and the vice chairperson before we go through items 5 through 9. That would require a motion for us to proceed to item A on the new business.
So motion to proceed to new business, the election of chairperson and vice chair.
Is there a second? Second. All right. So with that, thank you very much. We'll move to new business item A, election of chairperson and vice chairperson. So I'll just go over briefly the process for the elections. For nominations, we'll be proceeding first with the chairperson and then the vice chairperson after that. In this process, the floor will be open for nominations for the position of chairperson and vice chairperson. After all nominations are heard, the period for nominations will close and we will move on to voting. For voting will be conducted on the floor and nominees will be voted on in the order they were nominated. Voting will be conducted with a show of hands, both in person and virtually. Once a call is made for voting, raising of the hand will indicate a yay or a vote for the nominee. Each raised hand will be considered a positive vote and counted as such. A total of 4 votes is needed for affirmative action by the board. Are there any questions to the process? If not, we will proceed. We'll now open to the floor nominations for the position of chairperson.
I'd like to nominate.
Yes.
May I?
Yes.
I'd like to nominate Attorney Shane Black for chairperson of this board.
Okay, noted. Don't make them all flooding in at once. You know, I wasn't sure how long you guys would want for this period, so I'll just ask the question. Will there be any other nominations other than? Okay. Our board members on virtual, would you guys have any other nominations other than Attorney Shane Black for chairperson?
No.
I don't have any nominations.
Okay, thank you very much. So based on this, we'll go through the process of voting now. Can I get a show of hands for everyone that would like to vote for Attorney Shane Black as chairperson? Okay, we have five. Five, oh. Okay, with that, we'd like to congratulate Attorney Shane Black on getting voted our chairperson. Okay, Attorney Black, I'd love to call you Shane. Yes. So Shane, it's like talking to myself. So at this point, because you are now the chairperson, either you can continue the election or you can have me continue.
I'll let you do it.
Okay.
Go ahead, Shane.
I mean, it's literally the same person, right? So, okay, with that, we'll open the period for nominations for vice chairperson. Would anyone like to offer any nominations?
I'd like to nominate, Dr. Ricky Hernandez for vice chair.
Duly noted. Do we have any other nominations? I would like to check with our board members online, virtual. Would you have any other nominations? Nominated at this point is Ricky Hernandez.
I would like to nominate Jeff Moot.
Okay, noted. All right. Attorney King, any nominations?
No, I don't have any nominations. Thank you.
Thank you very much. Without any further nominations, we'll go ahead and move to voting. We'll start first with Dr. Ricky Hernandez. Can I get a show of hands for the yay votes for Dr. Hernandez? 1, 2, 3. Okay. We have. Sorry, can I see the hands again? I just want to be sure. Okay, may I get a show of hands for Attorney Jeffrey Moot for vice chair? Okay, let it be noted that with 4 votes for affirmative action, Attorney Jeffrey Moot is now our vice chairperson. Congratulations. Okay, so with that, I would like to, of course, turn it over to the chairperson with the recommendation. First, I'll help walk you through everything. With the recommendation that we proceed back to item number 5, so we can go ahead and go through the housekeeping and get down to the discussions. Notwithstanding, we have completed new business item 8. So with that, if anyone would like to.
I'll motion for the
Motion,
minutes.
Thank you. Do we have a second?
A second.
Thank you. Okay. So, Chairperson Shane. Generally, at this part of the meeting, we would call for a motion to approve last meeting's minutes. We do understand that at this moment, we do have our board member, Ms. Donnelly Kanata, who was part of our previous board. So as far as substance, she kind of tested the minutes from last time. So if you want to proceed, you can go ahead and request for a motion to.
Do you have anything to add?
Motion to accept the minutes, subject to corrections if there is.
Any corrections that you see?
No, not as I saw it.
Okay, and at this point, we would just need a second to approve minutes from last meeting. Second. So at this point, Chairperson, you may proceed down to old business.
Okay.
And if at this point in time you would like either myself or the executive director to go ahead and brief on it, you can request us to do so.
I don't know who's the best person to bring on this, but.
Well, I mean, I could go ahead, so the resolution. We have a motion on the floor that hasn't been voted. You made a motion to approve, he seconded, so The next step is to, their approve
Oh.
or disapprove the minutes. Or the day budget fast. Put an order there.
Good thing
Put
you're
it-
vice chair.
It's great that you guys are sitting next to each other.
All right, can we have a vote on approving the minutes?
Vote for approval of minutes.
All in favor?
All in favor? Aye. All good.
Now, moving on to the next order of business. So whether it be Steve or Shane, whichever. is-
Yeah, I can take her this. So the resolution basically 0725, which is attached in the packet. It wasn't actually, we never received the original signed by.
That's correct. It wasn't signed by the chief justice and the presiding judge. Generally in previous meetings, it was a vote of affirmation.
Discuss it? Does it have to be motioned in second before we discuss it?
Oh, for
I
the,
didn't-
for old business?
No, for the, I'm just asking on the resolution that we're gonna discuss it, because
Yeah, no, we don't think, because it's not a resolution for us to pass, it's a resolution that, in theory, Chief Justice and the presiding judge actually didn't have the authority to process. Because this is apparently done after the governor signed Public Law 3848, which removed them as the people who,
normally.
there was no Public Defender Service Corporation anymore. So this whole resolution is sort of a nullity, probably why they didn't sign it. Because it makes, the last whereas was signed into law by the governor of Guam on the 18th of August 2025, and now Public Law 3848. So on the 19th, the Board of duly noticed meeting of the Board of Trustees. That's an incorrection because there was no longer Board of Trustees at.
Well, it was like a
Well,
lead-in period.
Yeah,
and
October
effective date.
1st is the effective date of Public Law 3848. And so, it's specifically, but they're not really. So at the time that this was voted on, they were still. Did they sign it? They didn't sign it, but they voted on it.
Yeah, I think background for this resolution, right, as they had instructed us to come up with the recommendations was, we had to hold the, August 19th meeting because it was a regularly scheduled meeting.
Okay.
I think the position of, the chairman and vice chairman at the time was we still have to hold it.
Okay.
And so they did, and their instructions to us also was to ensure that it's noted that it's a recommendation only.
If that's the case, then we're not actually a Board of Trustees today. Because I forgot, it goes into effect 1 October.
It allows for meeting early to do stuff like this.
Yeah, that's cool. Says we can be appointed in order to adopt policies and procedures. But anyway, but that's correct. These are just recommendations. Yeah, okay, to the new board.
To ensure some continuity and. Well, if you had any more to present on these particular items as a recommendation before any kind of motion or anything is made, then certainly like here.
Did you want to be brief background on the resolution?
Yes.
Well, I mean, we're really gonna address it when we get to new business owners, because all of those recommendations were incorporated into the new business resolution. Section C, so we could just
So we can just move on.
move, yeah,
Right.
that's correct.
Yeah, we can move through it.
Okay.
It was really mainly for informational purposes for the incoming board to see what the current procedure is
I see.
and how the board was recommending this certain procedure.
Okay, well, I guess we can move on to new business aside from A, which. Is there anything else to present with regard to the pilot here.
That's section B. I think it's on page ten of the, yeah, and really these bylaws, the proposed changes would just to make it consistent with the change in the law, public law, the 848. And it changes things like the place of meeting, and also the voting requirements now requires a vote, changes the membership. We did include a comparison chart.
Yeah, the comparison chart for the changes is on page 50. Page 50, yeah. That shows what was
And so none of this is, it's all basically pulled from the statute. And it just changes things like now it requires a affirmative vote for actions by the board. And then, of course, changes the chair and vice chair, like previously was the chief justice or the presiding judge. The agenda setting or method of voting. All these pretty much are just changing the number from 3 to 4 votes. Same order of business. Of course, the board membership. And the chair, vice chair vacancies, how those would be filled. The secretary remains the same as administrative director. And pretty much everything else is the same. We did include the board powers that forth in the statute. It's kind of a little more detailed than most bylaws. And so it's just incorporating the statute into our bylaws. Not really that necessary, but I thought since the board has the bylaws and read it, it would listing their powers there would be very informative. And then the indigency criteria, how they're going to develop that in the future. The appointment of the executive director, that changed. The performance evaluation now is going to be annual as well. Qualifications for managing attorneys will need to be established by the board. Not necessarily in the bylaws, but we could pass a resolution for that somewhere down the road. So these are all the different powers: budget and oversight, setting forth the appeals and grievances for employees. Different powers of litigation authority of PDSC, as well as the power to control our facility and also all our additional powers regarding promulgating rules related to HR, fiscal procurement, and other things like that.
To Jeff's point, I know Ron indicated that we are allowed to meet to go over some of this stuff, but if we're not officially aboard till the 1st of October,
We're allowed to, adopt its policies and procedures, so it's like the probably our bylaws we can do.
Yeah.
But I don't know about the rest of you, but I don't remember getting a copy of these before today. Did you get a copy?
I think there was a copy, but it was quite lengthy, so I don't know that.
I haven't had a chance to look them over.
Not in any detail, so I wouldn't.
Yeah.
No, it's not something that needs to be passed today because the statute trumps bylaws and.
Yeah, okay. So, I'd like to move that we table those until our next meeting. And then you'll
You're the second one,
Second.
all in favor? Anybody opposed? No? Okay,
I just want to say, I really appreciate the fact that you guys went to all that effort. They can go through with the chart, and everything, so thank you.
Okay, on to the next thing. Bylaws, resolution adopting proposed regulations and procedures for the private attorney panel.
Do you want to just put that on hold too until the rest of the?
Well, I'd like to hear if there's any presentation about this or any background history so that, you know, all of us can read the documents, but if you have any insight from prior meetings or anything, I'm sure that will help everybody in the future meetings.
Yeah, and I think this is the one that we're hoping, we actually need passed because October 1, we're gonna be implementing it. When the bill was first introduced, there was a 3-month window that we were given,
Mhm.
but then due to the delay, the passage of the law and executing the law, shrunk down to like 3 weeks basically. So October 1, we're gonna be responsible for paying the private attorney panels for work performed after October 1, but for cases that,
So it's just about payment,
yeah, and also selection.
house selection too.
Problem is, these are rules that are not for our internal operation, so they're subject to the AAL. So we have to go through the administrative adjudication law. Section 3 means that whole process. So. I went through the statute, I didn't find any exceptions for us not to be subject to the administrative adjudication. If I've missed it, let me know.
So there historically, so the Public Defender Service Corporation currently, we're not really like, we're not a line agency. And we're kind of an entity that really, it's kind of an anomaly, right? Because we're not really performing an executive branch function. And so when they passed Public Law 3848, they kind of defined us as an entity that falls under the supervision or jurisdiction of the judiciary and the legislature. So the AAA applies to agencies, right? And the definition of agency specifically excludes entities within the judicial or legislative branch. You know, we've looked into the research that we've done. You know, one, we're not really an agency, and 2, we fall under Title 12, which relates to autonomous agencies. There are like 12 different autonomous agencies listed. In all of their enabling statutes, their boards are required to comply with the AAA. The Public Defender Service Corporation, as long as we've been under Title 12, we've never been required to comply with AAA, like pretty much all the other agencies or autonomous agencies. And I'm not sure if that's just because of unique, you know, our unique role in the government, right? We're representing individual defendants and we don't charge fees. And so, yeah, that whole issue is we're not specifically required to comply with the AAA like all the other autonomous agencies in Title 12. But then, you know, we're not specifically excluded. And so, you know, it's one of those things lawyers can debate, but the way that this statute's structured, if you're an executive branch agency under Title 5, he automatically applies to you. If you're an autonomous agency, the legislature specifically requires or the autonomous agency to include the AAA. And so I have the sites for all those if someone wants. I just did a really quick research on it. But yet, I mean, it's tough. We're not really an executive branch agency, but we're not really attached to the judiciary or the legislature specifically. But when they established us, they just call us an entity within the government of Guam, subject to the Supreme Court of Guam and the legislature in Guam has inherent statutory and organic authority. So I think that would kind of keep us out of the definition of agency.
Does anybody else have an opinion on that? From a legal perspective or otherwise? I just have a question.
This is Joseph. Oh, sorry. I was actually looking it up too while you guys were talking. I thought government agency it applies to all. Is there a definition? I'm trying to look up the definition. I was looking up this up last night and I couldn't pull up the exact definition right now as we were looking it up. But my understanding last night was that it's all government agencies are under the AAA. But I may be mistaken as far as like was the court does the court is the court an exception when it was under was when PD was under the court for its
Yeah.
rule adopting? Okay.
There's an exception, an agency does not include a legislative or judicial branch.
Judiciary, yeah. Okay.
The word agency means,
Any entity in the legislative judicial branch.
but we're not an entity under the judicial branch anymore. We're not an entity.
I know, but when we were never identified as an entity within the judicial branch. There's, in the history of PDSC, there's really no law that specifically placed PDSC within the judicial branch. It just, well, assumed that because the chief justice.
The chief justice was the person who was sharing it, but now we're definitely not a judicial branch. Because they sent us off as, we're not funding you anymore, we're not doing anything, and we're not part of the legislature. And under the Organic Act, there's only 3 entities, so if you're not in the judiciary, you're not in the legislature, you're an executive branch. And that's in all entities, so.
Well, I think we're an autonomous agency that's, I don't know, it says we're an entity within the government of Guam, subject to the court and the legislature in Guam, and there doesn't really mention executive branch anywhere in our.
Where are you,
statute.
where are you finding that?
Let's, 12 GC, section 11-103, but this is the new law, public 3048, I don't know if it's up on.
That was the entity within the government of Guam, subject to the Supreme Court and the legislature's inherent statutory and organic authority. Well, the legislature doesn't have any authority. Legislature's authority is to enact laws. They don't oversee any agencies. And the Supreme Court, of course, is involved because they oversee the practice of law. But this within the government of Guam, subject to the court, well, also every entity is subject to the Supreme Court and the legislature. Inherent statutory organic authority.
Yeah, and the difference is that in Title 12, where all the other autonomous agencies are listed, each one of them specifically requires the AAA, but you know, for some reason ours was excluded. I think it's
But the
and then
definition,
legislative intent to treat this board a little differently than all the other autonomous boards.
yeah, but this word agency used in this chapter shall mean and include any board, commission, department, division, bureau, or officer of the territory of Guam authorized by law to make laws or adjudicate contested cases, make rules. An entity in the legislature and judicial branches are excluded. And so it is the Guam Power Authority. So nobody else is excluded. And if we are an entity within the legislature or the judicial branch, then the governor has no authority to appoint anybody in either one of those branches. And so I don't know how we would be established. If we're not under the control, the direct control of the legislature or direct control of the chief justice, then even an autonomous agency within the Title 12, they're all executive branch agencies.
Yeah, but the legislature specifically requires those boards to comply with the AAA, which means there's a legislative intent that if we want the AAA to apply to an autonomous agency, will specifically state it. Otherwise, that's surplusage, and I don't know if the court would consider that surplusage when 13 out of the 14 autonomous agencies are required to comply with that requirement. But you know, it should have specifically excluded us, that would be better, but when you look beyond plain language, so look at how, the legislature treats all the other autonomous agencies.
Yeah. Rules, statutory construction is read the law, read the statute. If it's not unclear, you adopt that interpretation. And we are a board within the government of Guam authorized to make rules, right? That's, all I'm saying is, if we make a half-hearted attempt to pass rules without going through the proper procedure, if we're required to, then the rules are void, and any attorney that's not happy with the rules we put out, of course, can just screw us over. So, I mean, I think right now we can keep with the process that is already existing. We can adopt, we can vote to continue the rules that the court has established. And then if we need to, and then we could look at and go through more detailed rules. That would be my suggestion, but, now I'm looking at the statute and I'm looking at the language that they put in here, that were established as an entity within the government. So subject to the court and the legislature's inherent statutory organic authority. I don't even know what that means. I mean, we're subject to the legislature's organic power because they have the power of the purse. And so all of our money comes from them now. And we're subject to the Supreme Court's control because they control the courts and they control the practice of law and the licensing of law. But I mean, I don't know where we fall other than in the executive branch otherwise.
Yeah, and the like me, I can't see anything that would associate us with the executive branch in either the statute itself or any of the legislative history. But, you know, because the appointment of counsel really involves the courts in exercise of, you know, the constitutional right to counsel, right? That's how they've been enforcing it. I think maybe we can interpret it so that if the rules relate to the Supreme Court's, you know, helping the court appoint attorneys, which is what these rules are designed to do, then that wouldn't apply to the
Well, the other thing is, it says under this private attorney panel, it says they receive a rate of 150 hours until the corporation develops and adopts alternative compensation policies in consultation with the Guam Bar Association.
That's correct, and they didn't mention the AAA in that.
And
So,
yeah, but we haven't done the consultation with the Quorum Bar?
oh, no, so the statute sets the rate at 150, it'll stay 150 until we complete that process.
Okay. Your concern is the method of appointment? That we have to appoint, we have to do the rules right now?
Yeah, I guess what's the repercussion of tabling the rules? What are we left with?
Well, the Supreme Court after October 1, or the court rather, might not appoint him.
So it's just appointment. The
Appointment,
money,
and-
we're okay.
Well, that will also, I mean, I think that that's part of FARCA, right?
Yeah.
Once they start providing services, then we'll have to pay them, right?
Yeah, I think a lot of what's in the proposed, rules, a lot of it mirrors the court, but of course, there's those internal processes, right, that we'd like to accomplish. Procurement and things like that. Any degree of, transitioning it over to.
But that's the stuff that's purely internal, we can do without that. That's
Right.
That's an exception under the AAL. The question I have is, you know, do we know for certain, what do we have for certain that says we're exempt from the AAL? I mean, we can make all sorts of arguments. My question is, I guess we're assuming that it's because you have to do it. You're saying because it's not in here explicitly that we're required to, that then exempts us from the requirement of the law, which says which defines us, but we're making an assumption that we don't belong in any branch of government?
I'm not saying, no, I'm just saying that the definition that the legislature passed was that we're an entity subject to the jurisdiction of the Supreme Court. Supreme Court is responsible for creating a system of representation.
Is there my question is there an agency anywhere in the government that's not subject to the jurisdiction of the Supreme Court?
Of the Supreme Court.
Of the Court of Guam?
I think we're the only ones subject to the
Yeah,
Supreme Court of Guam because because we practice and we get our license from the Supreme Court. Is that what you're asking?
The intent may be a little different, yeah.
Yeah,
Yeah, it's
I
kind of-
don't think anybody else
Specifically says
specifically
that you're,
has jurisdiction over an agency from the Supreme Court.
I guess to Jeff's other point, I mean, is it fair to say that all these rules are really just an internal process where we would be able to process private attorney panels requests for payment?
I think the only ones that are gonna be, that are not, are the qualification, like if we're gonna qualify who can be appointed and who's not. So externally,
Right,
but
those
if
were,
it's how you process things internally, then that's according to the AAA or the AAL. Internal operational procedures don't require
okay.
the Article 3. So, I mean, if you're saying we can't pay them, like creation of a pending list and who can be appointed and all of that.
So would it be fair for us then to take a look at it, separate what we would consider operation?
Yeah, I mean, the operational
And
stuff, I
then-
got no problem with just saying today, if that's what you guys need.
It seems like that's almost all what this is
Right,
like,
so they-
how do we process?
But we don't want to call it rules.
Right.
They would just be operating procedures.
Operation.
Yeah.
Yeah.
And that's anything we label as rules that may be applicable to somebody outside. I think we need to really sit down and look at whether or not, how we're gonna. If we don't want to do the AAA, which, if we can come up with a good legal memorandum that says this is why we don't. And the board's comfortable falling back on that, then we're good. We just have to be ready to defend it. If it's all internal, then we're not subject to that anyway.
I think this is pretty much internal. I mean,
Yeah.
it's
Because it's how someone gets paid,
how they
their
they're
invoice
able to
in,
be paid.
whether it's
I
accepted.
mean, we're calling it a rule, but it's really internal. And
No.
it does basically for the qualification of attorneys. It doesn't apply to the public in general, just attorneys that practice under Guam law.
Income guidelines are all internal.
Okay,
Yeah.
so
Let's just change the.
I want to make a motion then that upon the representation of the staff, that we adopt temporarily the operating procedures that are currently labeled as rules. Proposed rule 1 through 7 and the attachments, that we adopt those as a standard operating procedure for the Public Defender Corporation. And upon further review, if we need to modify them, we can do so at a later time.
And
That
you
makes
would
sense?
say that it would be the standard operating rules specific to the PAP.
Yeah, the PAP, so proposed rules 1 through 7 and attachments A through C, that we adopt those as internal operating procedures for the private attorney panel processing by the corporation. Does that make sense?
Well, it makes sense, but I mean, if we're gonna say that the AAA applies to us, then do we need to submit our SOPs to the AG for approval?
No, because they're internal. The AAL has an exception for internal operating procedures of an
And
organization.
so, and that's what I mean, I don't know if we need to concede that point, because at some point, if we fall within the AAA, then we're gonna be obligating ourselves to getting contracts approved by the.
You're gonna have to do that anyway, because we're now getting money from the general fund, right?
We've always gotten funds from the general fund. We've never had to go to get an AG to sign off on a contract. Could you imagine getting Doug to sign off on a contract for a criminal defense attorney? Do you really think that's gonna happen? And that's the whole reason the legislature never required us to comply with the AAA like they required the 12 other autonomous agencies listed in Title 12. It's because we have to get the AG to sign off on all of our contracts. You know what it's like to get them to sign off on contracts. This whole system will shut down. And so that was not the legislature's intent, and I think in their wisdom, that's why they specifically, I mean, maybe they should have gone one step further and specifically exclude us, but the fact that they did not require it in our naming statute like they did it in the 12 or 13 other autonomous agencies, it, says a lot, so, but, I mean, as a temporary fix, this could work, but I think we need to address that.
Well, that's why I said,
issue.
I'm making this temporary because if, I think we as a board need to have, detailed legal memorandum explaining your position. That's what I'm thinking.
And do we get an AG opinion on that, whether the AAA applies?
No,
I mean, see the slippery slope.
We don't want
it's going, right?
how about this? Why don't we suggest, I mean, because of timing, right?
Yeah.
Is there a way that we can recess this meeting until, let's say, the second? And then would we have to, advertise it, we say that we're having it till the second, and then,
Continue, you don't need to advertise it.
okay, so we continue, we don't have, but then it allows us to do what we need to do, and we'd have time to read this. I'm sorry, sir, it might be easier for us to do this instead of us going back and forth trying to figure out whether we can or we cannot. Why can't we just, because time right now is what we're dealing with, why don't we just recess this until the second, which is next week, Tuesday, right? Is that, or when is the second? I'm sorry.
Second,
Thursday.
Thursday.
I mean, if anybody has, then we would actually be able to say what we can and cannot do without anybody challenging us. And then we can accept what we need to accept, and it gives us time to read what we need to read and go over and see if we can find what we really want to find. But I really don't think we want to open that Pandora's box where we're going to have to go to the agent's office. I mean,
And in that time, just entertaining that for a second, is it possible to get a legal brief about this issue so that those of us who are not government attorneys or attorneys at all?
I wasn't a good understanding. This has been my life now for the last 3 years.
would that be a good out of the box
Well, I
thing to
think
think
the
about?
vice chairman's idea would work for now, and then we
We
just deal
can
with
just
that.
take it up at the end of the
Yeah.
year.
So we have
Yeah.
So we
One
just temporary is, yeah,
one
so,
motion on the table, do as far as adopting them as operating procedures, current for a temporary purpose. Do we have a second for that?
Second, because we
Okay.
need to discuss it,
Okay,
right?
okay, all in favor?
So everybody's done with the discussion though?
Well, oh,
Everybody
just-
up there?
what is, anybody,
just so you are clear, I want to get these into place so you guys can use them. And then if at our next meeting, we determine that we need to do something more, then we can figure that out. We need a little bit of time, because I'm still trying to process. Personally, I'm trying to process what it is the legislature actually created. Because we're in the middle of a lot of litigation involving the Attorney General over what everything means. And currently, the governor's position is, if you ain't the court and you ain't the legislature, you an executive branch. And you gotta follow the executive branch, you gotta follow the laws. And we sued and won against the Attorney General that he has to comply with the Centralized Accounting Act. Even though he is an elected official position, has a position under the Organic Act. And the court has ruled that he's gotta submit everything to the governor. And that 22-601 applies to every contract. If it involves a government entity.
Would a week be
Yes.
enough for time? I'm just asking because would a week be enough time to get that information, sir?
I'm gonna suspect that people need to get do a little bit more deep research. I mean, I'm working on it too, but you know,
Yeah, there's a huge difference. The Attorney General's office falls under Title V, Executive Branch Agency.
But
We're
the-
autonomous.
Without conceding the point though, if
Yeah.
we were to
okay,
put ourselves in the position where we adopted these temporarily as operating rules, what position, I mean, how will that affect you?
No, I mean, we'll comply.
but
I mean,
you can use them, right? I mean,
Yeah,
they'll
no,
work and
yeah.
they'll take care of your problem.
Yeah, all right, no problem, yeah.
Yeah.
Oh,
But yeah, I mean, that's why I made the suggestion, because the Supreme Court in Ray Leon Guerrero, 22 agencies, even said the autonomous agencies, the only reason they don't have to comply is their income producing. So that's like Ricky's at the airport.
yeah.
They're not stuck with the centralized accounting act because their income producing. Same with the port and the utilities. But the Supreme Court threw everybody else into the centralized accounting. That's the only concern I have is based on the Supreme Court's ruling. That's where we're at. And if there's one agency that the Attorney General is gonna screw with, if you can, it's this one. And that's my concern. That's the only reason I'm being really picky on like whether or not we have to do the AAA, whether or not, when it comes down to procurement, what we're gonna have to do. We don't have exceptions from, there's nothing in here that actually creates an exception
From the triple.
for the AAA or from the regular procurement proceeding or the centralized accounting. It's my concern is the legislature drafted it without thinking about, or it was drafted without thinking about all the intricacies of accounting and all of that stuff that comes with the government. We may need to go back and have amendments to the statute and some.
Why, can I speak?
Yeah.
I think that because it was one of those things where it's like, well, we need something with the judiciary out because it's the conflict. And the intent was continue the way we had been.
Mhm.
And now we see the gap is that because it specifically didn't say, and by the way, you still don't have to do the AAA. I think that's where the gap was.
Well, but when they took the court out, the
No.
court basically ran things and
Right.
nobody's gonna challenge the court.
Right.
That's the fact, but, I've been trying to understand the statute and figure out how it works ever since it got passed, because, I had to, I wrote the signing statement for it, and I've been, I had to prepare all the briefing stuff for it, so I've been trying to figure it out, and I got problems trying to understand it. And that's my concern, is that we just treat these as internal operating procedures. We don't even worry about the AAA argument right now, and that we try to figure out other things as we go forward, but.
well, in the interest of time.
Yeah.
I mean, you raised very good points, Jeff, and we certainly have a lot to consider. But it sounds like we have at least a temporary solution that will get us through till maybe the next board meeting. Is that, or is
Yeah,
that too presumptuous? Or do we need to have a meeting earlier?
Yeah.
Well, I don't know, I mean, just to get the path up and running, these rules will work, and then obviously we're gonna tackle these other issues because, historically, we have a 100% separate accounting system, but according to trustee rules, now we have to go through DOA for it. We are our own DOA in HR, in procurement, in financing, and it doesn't sound like that's going to continue because that's what the structure was enacted by.
I think not everybody here is informed enough to really
No.
parse through the two of your arguments. You both are making valid points on both sides, but we don't want to be here forever.
Oh, no,
either.
so maybe that's.
I think if I can procedurally, we were just in the middle of voting down to to accept the.
Right,
as interim. So
yeah.
maybe we can complete that. And
Yeah,
then,
and move on to the next point.
So I
And
think,
we can.
And then we
address
can
another meeting
revisit
or
it
whatever.
again and then
Yeah.
put a
Yeah.
stamp.
so I
to it.
believe you had a second. And
Yeah.
it was
So
all in
he
favor, Paul?
Yeah.
motion, I second and up
All
for
in favor.
discussion. All in favor for the vote.
Any nays?
Any nays?
No.
No.
Okay,
Now, discussable.
Yes.
Are we going to wait till the next meeting or are we
Yeah.
gonna be able to
is there,
have an earlier meeting? That's up to you guys.
right, these other things on here, so. Meaning the official board of trustee meeting details. I don't know what that means.
That's just generally housekeeping. The question of currently it's every fourth Tuesday, 12:30.
Oh, is anybody
I mean,
opposed to this? time?
Yeah, if you guys are okay with that time
Anybody
and
have any issues?
Well, it's not a, I mean, I prefer to meet in the evening.
I'm swamped in the.
Yeah, because the problem I have is, you know, getting away from work is not always easy, but if this is the time that they want, that's fine.
Then we can still Zoom. We're still allowed to Zoom, so.
yeah, so
Should we vote on it or?
basically,
And sorry if I may, on the 4th of October, I'm on drill status for the National Guard too as well. So that weekend, the 4th and the 5th, I'm on drill.
Something to consider, we can
Yeah.
table it.
Yeah.
I can discuss it
Right.
more, it's no problem.
Yeah,
continue.
I mean, whatever you guys said, it's just, these are not always. You know, during the day is.
So if we do decide to table it, the next meeting currently is scheduled for October 28th, so we can take it up again.
okay.
Then.
Okay.
On that point, is that, have we done enough to, that you guys moving for October 28th? Do we have to have another meeting earlier for any issues that you might foresee?
I don't foresee, especially since you guys approved the rules. We just.
The internal operator got a seat there.
Got to stop going there.
Internal operation procedure.
Yeah, now we're gonna have to learn. Boys.
Okay,
Can I just say just a note on the agenda, it does say proposed regulations and procedures and state rules. If that makes any difference. I know the rules. It says proposed rules on the operating procedures. But it doesn't say
Okay.
that.
okay.
Good eye.
So everything else, we're good to go on this meeting, executive director form, we're good with tabling now, or is there anything else on here that needs to be addressed?
But Chairman?
Yeah.
If I may, so I know we're gonna table some of the discussions about the AAA for next meeting. Is it possible that we could still circulate any research material that the other board members may find in regards to fleshing out the issue prior to the meeting? Is that a possibility?
Sure, and to the executive
Oh, no.
director.
Yeah, I think as long as, I mean, maybe we'd want to centralize it with the secretary and I can send it out to all the board members, right? So, you know, there's no emails between, board members inside of the discussion.
Right.
So, yeah, if you want to send it in this way, we can definitely send it out to all the board members.
That would be
Appreciate
great.
it. Thank you.
Okay.
So Chair, do we need to go to any next item after?
That's what I was trying to, so we went to the meeting details, executive director appointment, continuity of operations. I'm not sure what you're normally discussing.
Yeah, so with section E, we put it as an agenda item, just because October 1st, right, everything comes into place. So that actually puts a term limit on the executive director. And depending on how the board wants to move forward with appointment, even if it's just for the interim, right? For continuity, right, to move forward. We thought to just put it on the agenda because of the effective date thing. I mean, it's already whole new requirement now, so. But to leave it up for discussion on, I guess, how else we handle Rachel.
Right, I mean, I think just most importantly is to have some continuity here while we deal with this interim period, so. It's
Yeah.
my personal hope that someone's gonna nominate to have Steve be the director, at least in the interim, and allow for continuity.
All right. Is there any motion to appoint Steve as an interim?
I can motion it.
I'll second.
All right. Any discussion related to that?
All in favor?
All in favor?
May I just ask,
Oh.
is it up until we decide on it being not interim?
Right, up
Right.
until we
Yeah, we
have a more salient discussion about it.
Yeah.
But for continuity's sake. So any other points? Okay, all in favor?
Aye.
Any nays? No,
No.
okay. Miscellaneous.
Okay, yeah, that was, you know what, I would actually recommend we just strike that. The intent of that was to have an opportunity for the board, to, you know, if there's any questions of us, right, that they had. But I mean, there's a lot on the table, so I'm assuming next meeting, that section will be gone. And it'll be very, very specific about. Yes, but yeah, that's my recommendation.
Okay. Public discussion.
Yeah, usually at this point, it's just call for anything else, public discussion, which is
Yeah.
basically anything.
Like announcement.
Oh,
Announcement.
well,
Until we see you.
George already made one.
Yeah, and if not, at this point, if there's no public discussion, chair will usually request for a motion to adjourn.
Okay.
With the next meeting date stated.
No, one more point. Before we go, I think we probably need to do something. The employees right now, whose personnel rules are they under?
We have our own personnel rules. We have our own procurement rules, we have our own, it's basically
HR.
Quite a few years old, they're modeled pretty heavily.
We have
after
our own-
Okay,
DOS.
I was just checking because it just says that we shall establish rules and regs. And I wanted to make sure you
Oh,
weren't
yeah.
doing, you weren't stuck under the court. So if there was anything, okay. Good. That's all I want to make sure.
Motion to adjourn then?
Okay, is there a second?
Is it adjourned or is it for the minutes?
Oh,
Yeah,
no, we're adjourning because they said the time was October. They didn't need it was too quick.
Yeah.
Over 20, yeah.
Okay, I have a second.
All in favor?
All in favor?
Aye.
Okay, any nays? No?
No.
Okay.
It's adjourned at 1:37. Thank you. That was fun.
Yeah.